The Salvation Army versus SSS GR number 230,095. Facts. The Salvation Army is a non-stock, non-profit religious organization that utilizes military terminology in its structure. In 1962, it registered with the Social Security System, or SSS, and initially listed its officers, who were religious ministers, as employees. In 2005, the petitioner requested the SSS to convert the membership status of these officers from employees to voluntary or self-employed members, arguing that the relationship was ecclesiastical, not employment. The SSS and the Social Security Commission denied the request, finding that all elements of an employer-employee relationship existed. This denial was affirmed by the Court of Appeals. Issue 1. Whether an employer-employee relationship exists between the Salvation Army and its religious ministers, making them subject to compulsory SSS coverage. Ruling 1. Yes. Applying the fourfold test, a secular employment relationship existed between the Salvation Army and its ministers. Asterisk selection and engagement. Officers undergo training and sign a formal undertaking. Asterisk payment of wages. Officers receive a fixed monthly allowance based on years of service, which qualifies as wage under the Labor Code, despite the petitioner characterizing it otherwise. Asterisk power of dismissal. The petitioner periodically evaluates officers and reserves the right to terminate services based on persistent ineffectiveness. Asterisk power of control, most important. The petitioner mandates its officers to accept and faithfully teach its doctrines, abide by its orders and regulations, conform to uniform requirements, and submit to accounting/audit of resources, demonstrating full control over the manner and means of their work. Issue 2. Whether such determination constitutes an infringement on the constitutional right to the free exercise of religion. Ruling 2. No. The inquiry into the existence of employment relationship for SSS coverage is a secular matter, not an ecclesiastical affair. The application of the SSS law, which promotes social justice, does not violate the non-establishment clause because the institution is treated as an employer and the benefits are extended to the ministers as employees, irrespective of their religious function. The SSS funds are held in trust, not public funds used to establish or favor religion. Doctrine 1. Coverage in the Social Security law is predicated upon the existence of an employer-employee relationship. Religious institutions are within its scope, as they are not among the exceptions enumerated under the statute. Jurisprudence has clarified that their nature as religious organizations does not exempt them from compliance. 2. The judicial determination, using the fourfold test of whether a minister is an employee for the purpose of mandatory Social Security coverage, is a purely secular legal matter and does not constitute impermissible intrusion into the internal, ecclesiastical affairs of the Church. The constitutional separation of church and state is only violated when the state meddles in purely religious matters concerning doctrine, creed, or worship. This case authoritatively reaffirms that even ministers and officers of religious organizations can be classified as statutory employees under the Labor Code and the SSS law if the elements of the fourfold test, especially the power of control, are met.